Everyone. In this video, let's discuss about the amendments in the areas of Companies Act and FCRA, which is applicable to CA Final May 2023 examination. So the first amendment would be in the chapter of meetings. MCA by notification hereby amend the Companies Meeting of Board and its Power Rules 2014 through the enforcement of the Companies Meeting of Board and its Power Amendment Rules 2021. With this, it has omitted the Rule 4. The Rule 4 was dealing with the matters not to be dealt in a meeting through video conferencing or any other audio-visual means. So, being Rule 4 now omitted, now we can discuss all matters via audio-visual means or the video conferencing mode. So, the second amendment is there with respect to the Foreign Companies Chapter. MCA by notification number so-and-so in excess of the powers conferred to it under Section 3 Companies Act 2013, the central government hereby exempts from the provision of Section 387 to 392, both inclusive, with respect to the foreign companies. The following foreign companies incorporated or to be incorporated outside India, whether the company has or has not established or when formed place of business in India, insofar as they relate to offering of for subscription securities requirement related to the prospectus, and all matters incidental thereto in the IFSC centers set up under Section 18 of the SEZ Act 2005. See, it exempts for the foreign companies and for the companies which is incorporated or to be incorporated outside India, whether or not it has a place of business in India, insofar it relates to the offering of prospectus and subscription to IFSC set up under Section 18 of the SEZ Act. Okay, then moving on to third amendment. MCA by notification excess of the powers conferred on so and so sections, the central government hereby enforces the Companies Registration of Foreign Companies Amendment Rules 2021 to substitute or amend the Companies Registration of Foreign Companies Rules 2014. Okay, so now please take page number 2 of the Foreign Companies chapter. Okay, that is chapter number 9. That is 9.2. Okay, then you could find, according to the Companies Registration of Foreign Companies Rules 2014, electronic modes mean carrying out electronically based whether main servers installed or not, including but not limited to. In that you find 5 points. In that, for point number C, an explanation has been added, which is that electronic based offering of security, subscription thereof, or listing of securities in IFSC center shall not be construed as electronic mode for the purpose of this clause. I am going to offer via electronic mode for in the IFSC center, then that will not be considered as electronic mode. Okay, then it's in the chapter of directors, appointment and qualification of directors. Okay, the earlier Companies Appointment and Qualification of Directors Rules 2014 has been amended via the enforcement of the Companies Appointment and Qualification of Directors Amendment Rules 2021. With this, there has been two things which have been changed. Okay, you can go to the page number 1.45. In that, under the main heading of manner of selection and of independent directors and maintenance of the data bank, you could find point number 4b, which says that in the pay scale of director or above in the Ministry of Corporate Affairs or the Ministry of Finance, Ministry of Commerce and the Industry, or the Ministry of Heavy Industries and Public Enterprises, and having an experience in the handling of matters relating to corporate laws or securities or economic laws. This entire point B has now been substituted or amended with in the pay scale of director or equivalent or above in the ministry or department of central government or state government, and having the experience in handling the matters relating to commerce, corporate affairs, finance, industry, or public enterprises, the affairs relating to government companies or statutory corporations set up under the Act of Parliament or State Act carrying on commercial activities. This point has been newly added. The affairs of the government companies or statutory corporation set up under the Act of Parliament or State Government and which is carrying on the commercial activities. Now, this is a proviso which states that for the purpose of calculation of 3 years referred to in proviso 1, any period during which an individual is acting as a director or as a key managerial person in 2 or more companies or bodies shall be calculated as only once. Right. So after this, another proviso is being added, which states that provided also that the following individuals who have been at least for 10 years as an advocate of a court, in practice as a chartered accountant, in practice as a cost accountant, in practice as a company. CA, CMA, CS and advocate, okay, shall not be required to pass online proficiency self-assessment test, but they should be in practice for at least 10 years, okay. Then move on to the next amendment, which is there in the chapter. Some rules have been amended, so let's see one by one, okay. First, the rule 3, which states with definition, a new rule with respect to the branch have been added. Okay, branch means a place other than the registered office of the Nidhi. Then, rule 4 was dealing with incorporation and incidental matters. Okay, in that we had a point which states that a Nidhi shall be a public company and shall have minimum paid up capital of 5 lakhs, minimum paid up equity capital of 5 lakhs. Now, this 5 lakhs have been increased to 10 lakhs. Increase it to 10 lakhs. So now the minimum paid up equity capital should be rupees 10 lakhs. Then a proviso has been added, provided that every Nidhi existing as on the date of the commencement of the Nidhi Amendment Rules 2022 shall comply with this requirement within a period of 18 months. Within a period of 18 months from the date of commencement, has to comply with the requirements within a period of 18 months. Then Rule 5 was dealing with the requirements for minimum number of members, net owned fund, etc. In that, this provision shall not be applicable after this commencement of this rules. Okay, this rule is stands omitted. It's like stands omitted. Okay, but it's applicable till the commencement of this new rules. But after that, it's not applicable. Then rule 6. In rule 6, we had a clause number D that actually rule 6 was dealing with general restriction or prohibition. In that, we had a clause D which states that acquire another company by way of purchase of no Nidhi shall acquire another company by way of purchase of securities or control over the composition of the board unless it has passed a special resolution in general meeting and has obtained the approval of the regional director having jurisdiction over Nidhi. This point has been substituted. Now, this point has been substituted, which states that no Nidhi shall acquire or purchase security of any other company or control the composition of board of directors or any other company in a manner whatsoever or enter into any agreement, arrangement or change of its management. See, there was earlier an approval clause. Now there is no clause. Okay, you cannot acquire the shares of other companies or control the other companies. Okay, then we had only point number K till point number K. Now a new point in K L has been added. So no Nidhi shall raise loans from bank or financial institution or any other source for the purpose of advancing loans to the member of Nidhi. Nidhi is a concept where you as a group help each other, fine, for mutual benefit. Now it goes on with the principle. So, no Nidhi shall raise loan from banks or financial institutions or any other source for the purpose of advancing loans to the members. In order to advance loan to the members, don't get finance from some other institution. Okay. Rule number 8. Rule number 8 was dealing with membership. Okay. In that, we had 3 points. One was Nidhi shall not admit a body, corporate or trust, and then it should not reduce the membership beyond less than 200 members at a time, and minors shall not be admitted. The point number D is being added now. A member shall not transfer more than 50% of a shareholding as on the date of availing the loan or making a deposit during the subsistence of such loan or deposit as the case may be, provided that the member shall retain the minimum number of shares required under subsection sub-rule 3 of rule 7 at all time. It should at least hold the minimum number of shares, okay, and it shall not transfer more than 15% during the period in which it has obtained a loan or made a deposit. Then rule number 9 was dealing with net owned funds. Okay, it said that every Nidhi shall make a net owned funds of not less than 10 lakh rupees or such higher amount. Now it has been increased to 20 lakh rupees. Every Nidhi should now maintain a net owned funds of 20 lakh rupees or such higher amount as will be prescribed. And a proviso has been added, provided that every Nidhi shall comply with this requirement within a period of 18 months from the commencement of this rules. Okay. Then rule number 14, it was dealing with unencumbered term deposit. Unencumbered term deposit. Okay. Now, it was given that in the case of unforeseen circumstances, temporary withdrawal may be permitted with the prior approval of the regional director for the purpose of repayment of depositors, subject to this condition as may be specified by the regional director. So, with the prior approval of the regional director, this approval shall be made by an application, by making an application in form NDH2. This could be an MCQ, please note it. Form NDH2 is used to make an application for the approval of regional director for temporary withdrawal of funds and unencumbered term deposit, along with the fee specified in the Companies Rules 2014. Then, Rule number 15 was dealing with loans. Okay, in that you have a point which said that a Nidhi shall provide loan money towards member. Okay, provided that now a new proviso is being added. Provided that in the case of joint shareholders, the loan shall be provided to the members whose name appears first in the register of members. The loan can be provided only to members. In case of a joint holders, then it can be provided only to the first member who is appearing in the list. Okay, then rule number 18 was dealing with dividend. Okay, earlier it was dividend shall a Nidhi shall not declare dividend exceeding 25%. Now it is higher amount. It was given as 25% or higher amount. Now it is stated that a Nadi shall not declare dividend exceeding 25% in a financial year. Higher amount. Okay, clear? Now it is only 25%. There is no higher amount. Then again there is an amendment in the directors chapter. Okay, Ministry of Corporate MCA by notification. Hereby amends the Company Appointment and Qualification of Directors Rules 2014 by enforcement of the Company's Appointment and Qualification of Directors Amendment Rules 2022. They shall come into force from the date of their publication. Okay. So, here. Now, let's take it. Okay. Take it from me. Now, in rule number 8. Okay. In rule number 8, after the proviso, the following proviso shall be added, which states that what was rule number 8? Rule number 8 was dealing with appointment and qualification of the directors. Now, provided further that in case of a person seeking appointment as a national of a country which shares land border with India, necessary security clearance in the Ministry of Home Affairs, Government of India shall also be attached along with the consent. For the consent, I have to attach the security clearance certificate from the Ministry of Home Affairs, Government of India. Okay, then there is an amendment in the area of allotment of tin, which is discussed in rule number 10. There is a procedural area, right? Now, which states that on submission of form DIR 3, requisite fees and application number shall be generated by the system automatically. Okay, for this a proviso has been inserted now, provided that no application number shall be generated in the case of the person applying for DIN as a national of a country which shares a land border with India unless the necessary security clearance from the Ministry of Home Affairs has been attached along with the DIN. See, for example, for instance, in the earlier case also it was said that I will not, together with the consent, I have to submit this security clearance certificate. So, in order to apply the application number also, together with that, then I have to submit this clearance, security clearance certificate from the Ministry of Home Affairs. Same point in two different areas. Now, then other one is respect to data bank. Okay, here what it states that Ministry of Corporate Affairs by notification the exercise of the powers conferred by Section 149 read with Section 469 of the Companies Act 2013. The central government hereby further amend the Company's Appointment and Qualification of Directors Rules 2014 through the enforcement of the Company's Appointment and Qualification of Directors Second Amendment Rules 2022. Okay. In sub rule number 6, which was dealing with the procedure required for a person who is eligible and willing to be appointed as an independent director. There were 4 sub-rules under it. Okay. So, in the 4th sub-rule was to pass an online proficiency self-assessment test. There was already a amendment here, right? We have discussed it. In the pay scale of director, we have discussed that point and also proviso, right? Now, there were 5 points under that rule number 4. Now, 6th point has been added. Okay. There were 4 sub-rules, right? Now, 5th sub-rule has been added. Okay. which states that any individual whose name has been removed from the data bank under sub rule 4 may apply for restoration on the payment of fees of 1,000 rupees. It could be an MCQ, 1,000 rupees, and the institution shall allow the restoration subject to the following conditions, namely his name shall be shown in a separate restored category for a period of 1 year from the date of restoration, within which he shall be required to pass the online proficiency self-assessment test, and thereafter his name shall be included in the data bank only if he passes the said online proficiency self-assessment test, and in the case fees paid by him at the time of initial registration shall continue to valid for a period for which the same was initially paid. And in case he fails, then his name shall be removed from the data bank and he shall be required to apply afresh for inclusion of his name in the data bank. See, somebody's name has been removed now. Individual whose name has been removed shall apply again for the payment of 1,000 fees for restoration. Okay, his name will be restored. First kept the restored category, okay, for a period of 1 year, but in which period he has to pass the online proficiency self-assessment test. If he passes, then the fees will be taken and then his name will be mentioned in the data bank, okay, or else if he fails, then within 1 year, then his name shall be removed from the data bank itself and he should come again from the first, okay, to apply afresh for the inclusion of his name. So with this, all the amendments in the Companies Act chapter has been completed. Now let's move on to the FCRA chapter. Okay, FCRA chapter. Foreign Contribution Regulation Amendment Rules 2022. Amendment Rules in Rules 6, 9, 13, 17A and 20. Okay, let's see each of these. Why notification? Just give me a minute. Yeah. Why notification? In exercise of the powers conferred by Section 48 of the FCRA, Central Government hereby makes following rules further to amend FCRA rules 2011 via the enforcement of the FCRA rules 2022. In the FCRA rules, in rule number 6, okay, in rule number 6, the words 10 lakhs has been substituted and the words 30 days has been substituted by 3 months. Rule number 6 was like, any person receiving foreign contribution in excess of 1 lakh rupees or equivalent thereto in a financial year from any of his relatives shall inform central government by for electronically online in Form FC1 within 30 days from the date of receipt of this contribution. This was the earlier provision. Now it has been amended to, write it now, okay? Any person receiving foreign contribution in excess of rupees 10 lakhs or equivalent thereto in a financial year from any of his relatives shall inform the central government by uploading the details electronically in Form FC1 within 3 months from the receipt of such contribution. 10 lakhs and 3 months. 10 lakhs and 3 months. I hope I have dictated it properly. Okay. Then we have another amendment in rule number 20. In rule number 20. Okay. Just give me a moment. Okay. Yeah. Rule number 20. On plain paper, the words in such form and manner, including the electronic form as may be specified by the central government, shall be substituted. Okay, instead of plain paper, now both the electronic form or such other manner as is allowed, as is permitted by the central government is allowed. Okay, now application for revision of orders under section 32 of FCRA read with rule 20 of the FCR rules 2011. In the exercise of the powers amended by rated, it is hereby ordered that with effect from 1st September 2022, an application of section 32 for the revision of an order passed by the competent authority shall be made in electronic form only through this website. Okay, from 1st September 2022, I should make an application for revision of an order by the competent authority only via electronic form. Only via electronic form. Only via electronic form. Okay. Then, let's move on to some frequently asked questions like it's being given. So, this could be an MCQ. Okay. Or it could be like a part of questions, sub questions. Who is eligible to submit the revision and application? Any person is registered under FCRA and is aggrieved of an order of the central government may prefer revision application in terms of section 32. In terms of section 32. Okay. Then any association file application for revision. It should be made to Secretary Ministry of Home Affairs in the electronic form only. Can be sent 15th August 2022. All applications are acceptable only in electronic mode. Okay. The order was passed in 1st September but with effect from 15th August 2022. What is the procedure for association to file an application for revision of order passed by the competent authority? Who wants to file an application may upload the scanned copy of its application on FCRA web portal under the main heading Service under FCRA Revision Application against Section 32 FCRA 2010. Is it required to send the physical copy of the electronically filed? No, only electronic forms enough. Is there any other format for revision application? No, one is scanned format or scanned copy of duly signed application. The plain paper is acceptable. Is the applicant required to submit a justification for revision of order? It's sure, yes. Justification for revision of order must be submitted online along with the supporting fees for revision of order 3,000 payment gateway specified by the central government. What is the time limit for making an application for revision of order passed by the competent authority? Okay. This is very important MCQ. This is a very important MCQ. The application must be made within 1 year from or date on which it is otherwise came to know of it, whichever is earlier, 1 year from the date of its communication, or otherwise when it was become to the knowledge of the party, whichever is earlier. So with this, we complete the amendments in the area of Companies Act and the FCRA. Stay tuned for SAB, LODR and IBC amendments. Okay, thank you so much.